Morning, please be seated. Okay, we're here for oral argument on EFG et al. Versus ACC et al. For number CV-25-0134. Before we get started. Each side has 20 minutes. As you know, you may keep whatever time you wish for rebuttal, but you have to keep your time yourself. So with that, please proceed.
Madam Chief Justice, and may it please the court, Adi Dainar for the petitioning parties, the company and its proprietors. The jury clause says that the right to a trial by jury shall remain inviolate. All parties agree that that means that there only needs to be substantial similarity between a common law antecedent and the modern cause of action. But the Court of Appeals did not do that Derendal analysis. We would have easily prevailed under that Derendal test. Instead, the Court of Appeals sort of found these penumbras emanating from Article 15's silence to conclude as a categorical matter that commission enforcement actions are ineligible for jury trials. We think that conclusion is fundamentally flawed for two reasons: the mandatory clause and the special law clause. The framers needed to say no juries in Article 15 to achieve the result that the Court of Appeals did, but the framers did not. For them to prevail, you'll have to read at least 4 different types of limitations into the jury clause, ignore a bunch of statutes, cases, history, and precedent. Occam's razor should be a sufficient counterpoint to that. We are asking you to vacate the Court of Appeals decision, conclude and apply the Derendal test, and put the burden on the government to show why commission enforcement actions are ineligible for jury trials.
How would it work, counsel, if we agreed with you and that there's a common law antecedent to this cause of action and they would get a jury trial? But then you do have Article 15, Section 19, which says that the Corporation Commission has the power and authority to enforce its rule by the imposition of such fines as it be deemed just. I would think the imposition, it's not seek fines, it's not sue for fines, it's imposition. So I'm just curious, how would it work? I know you say, well, they need to go over to the court then and ask for the imposition of fines. Can you walk me through how that would work with the language about, seems to be the suggestion that they get to impose the fine?
Sure, thank you. So impose, the framers use different terminology in Section 19 and 16. In 16, they said recover before a court of competent jurisdiction. And in 19, the framers said impose, they have the power to impose fine that they deem that, so there's a may in there in Section 19, and that's just permissive authority. That's not mandatory. That's my first line of reasoning. The second is, as a practical matter, we are an affirmative waiver state. So there's always an assumption that there is a right to a jury trial. And we have never had a rule where the prosecutor has the unilateral choice to basically, delete the right to a jury trial for the defendant. So practically what that means is if the enforcement target demands a jury trial, as the company and its proprietors did here, all that the ALJ can do is dismiss that administrative matter, and then it's up to the enforcement division of the commission to file basically the same complaint in superior court where trial would be by jury. So the imposed fines sort of recognizes, and the legislature has recognized this, authority of the commission to either proceed administratively or in superior court.
Mr. Dainar, there seems to be a statutory analog to that, which is 2037B, which also provides for a court action and concludes with the words, "Nothing in this section shall be construed to limit the right of a party in an action under this section to a trial by jury." How does the statute interact with the provision that the Chief Justice asked you about?
That's exactly right, Justice Bullock. And that statute recognizes this basic principle that everybody is assumed to have a right to a jury trial, and you have to jump through affirmative hoops to actually waive your right to a jury trial. And many parties waive their right to a jury trial. Their own statistics show that a vast majority of their cases, the administrative cases, are basically consent agreements. They are settled through that process. But there are 16 cases like this one where the parties want to assert their right to a jury trial, and then the statute provides that mechanism. We have a whole title devoted to juries in Arizona, Title 21, and Section 21102F, for example, recognizes this affirmative waiver principle. The Rule of Civil Procedure 38 also recognizes this affirmative waiver provision. That has always been the case in Arizona.
Well, counsel, but before you go further, because the other statutes that you cite seem to assume in the first place that there is a right to a jury trial in a particular matter. You've referenced 2037, but 44-2036 would suggest that there are different specific ways in which the Corporation Commission could proceed. They could choose just to go the administrative route. And one important distinction between 2036 and 2037 is the amount of a fine that could be imposed. In fact, 2037 contemplates offsetting whatever fine that got imposed by a court there, where there's a right to a jury trial, by whatever may have been paid in an administrative penalty imposition. So how do we reconcile that? What does Auckland Razor tell us to do?
Thank you. So that actually supports our position, because as I was answering to Madam Chief Justice's question, the Commission has that option to either use the 2036 route or the 2037 route. When it chooses the 2036 route, all that the enforcement target has to do is demand a jury trial if they want a jury trial.
And where does that authority come from?
Well, the jury clause says the right.
So I want to avoid going in circles.
Yes. Well, so
You're
ultimately,
basically, I mean, the argument so far they understand is there's a right to a jury trial, so there's a right to a jury trial. But the statutes very clearly provide two different means, one which explicitly contemplates being able to request a jury, and another one that doesn't, which seems to suggest that under an administrative proceeding, there's not necessarily a right to a jury trial. There's still a right to appeal in judicial review. So help me understand the difference there without having to go back and say, well, there should be a right.
right. So, for example, I said the prosecutor should not have the unilateral choice to cancel the defendant's jury right, and that has been the legal principle in Arizona forever. So
But I don't want to confuse an administrative proceeding with a criminal proceeding, because we actually have three different types. There's administrative, civil, and then criminal. So are you saying that when it comes to juries, there really is no distinction whatsoever? In every administrative proceeding that can impose a penalty, there has to be a jury trial?
Yes, there is no difference. And if you look at the penalties, the administrative penalties in 36 and 37, it's the $5,000 cap because it comes from Section 16 of Article 15. So there's no difference, materially speaking, practically speaking, between administrative penalties and civil penalties. They are just $5,000. And if you look at cases like Hirsch, which was decided by the Court of Appeals, these fines can run into the millions. There was $4.65 million in fines because of the way that Section 16 reads for each violation. So they apply a multiplier for each day and for each violation. So this is not a trivial penalty. These can run into the millions, and my clients are asserting the right to a jury trial. They should get that trial.
Counsel, let me take you back to Darendal. That's something that the Court of Appeals, as you stated, didn't really engage in. The Blue Beach Bungalows Delaware case was instructive to me. It seemed to be very, very similar to our constitutional setup and our test that Darendal sets forth. And in that case, that went against a person in your client's position. How is Blue Beach Bungalows not instructive and not controlling, I'll put that in quotes, in this matter?
So two responses. First, I think their argument is that in 1951, when the state legislature enacted state securities law, they did something so brand new that there can never be any common law antecedent whatsoever. So we push back against that premise because the State Securities Act was based on the Federal Securities Acts, which were passed in 1933 and 34. And we know from federal cases that federal securities law is based on common law. So there's a direct line that goes to the common law. That's my first response. My second response is Delaware, all of these sort of northeastern states like Vermont and New Hampshire, they give you examples of those states. Those are affirmative exercise states. We are an affirmative waiver state. In those states, there is no assumption that you get a jury. You have to jump through affirmative hoops to actually get a jury in a case. We are the exact opposite. To the extent that this court views those Delaware cases or Vermont, New Hampshire cases as persuasive, I think they can be easily distinguished because of the unique protection for jury rights that we have in Western states like Washington and Arizona.
So then your position is that a jury trial would be required in every commission case regardless of the statutory elements?
No, so I think it's a claim-by-claim approach, and Jarkissi, the U.S. Supreme Court, said as much. And the claim-by-claim approach is you have to look at what sort of causes of action the commission is pleading in the notice of charges. Here they have pled fraud, unregistered securities, unregistered dealers. So you have to look at those causes of action and see if there is a common law antecedent. Antecedent just means in the dictionary something that came before. And easily there is common law antecedent for both the cause of action and the remedies they are seeking, including injunctions, cease and desist, fines, restitution, and disgorgement. So that's the Derendal analysis that the court would do.
So there has to be just a sort of a general pairing and not substantially similar elements?
Well, substantial similarity is the test under Derendal, but substantial similarity is a very low bar. And Derendal, in footnote 3, for example, sort of expressed his frustration with requiring the defendant or the enforcement target to come up with, do all this research into William Blackstone and come up with reasons why this particular offense they're charged with is eligible for juries. The burden under Derendal footnote 3 and accompanying text is on the government because the government is expected to have solid legal representation and the resources to do that sort of legal research to show the court why a particular cause of action is ineligible for jury. So we are asking basically the court to apply that Derendal analysis, in this case and conclude that there is a right to a jury trial.
So Derendal uses that phrase "substantially similar elements," and the point made by the commission here is you line up the elements for the statutory provision under Arizona Securities Act with the common law fraud claims, and they really are. You count maybe 3 on one side and 9 on the other side. Why what is your response to that? And especially in conjunction with the fact that we have that term substantially similar elements in paragraph 39 of Derendal.
So it's not sort of like a one-to-one correspondence of elements, and Jarkissi, when it talks about the cause of action prong under the 7th Amendment, essentially does the exact same analysis. You don't need one-to-one correspondence. The statute could be narrower or broader than the common law analog, but that really is not relevant under the substantial similarity analysis. And on a basic level, Your Honor, if you look at common law fraud and securities fraud under the statute, it basically gets to some sort of a material misrepresentation, deceit, cheating. And on that sort of same character and grade is the language that Derendal uses. Our position would be that, we easily satisfy the substantial similarity test. Now, the problem is if you do conclude that there is no substantial similarity, I think you run into the incorporation problem because under the 7th Amendment, you have this very robust protection for civil juries, as Jarkissi recognized, and Jarkissi goes back decades, centuries to Murray's lessee, which was like an 18th century case. So we have had a long tradition for civil juries, we just have forgotten about it. So we are just asking you to reaffirm that principle today.
Counsel, ask a question about what we've forgotten, because the imposition of the 7th Amendment was intended in no small part to protect the people writ large against centralized authority in the federal sphere. But states were free to protect rights as they saw fit at the state level. So this effort to incorporate the 7th Amendment or rely on 7th Amendment jurisprudence, isn't that using a sledgehammer to try to force states to now interact with their citizens the exact same way that the federal government was supposed to be limited in interacting with citizens in a national sense? I guess my question is this: why do we have to follow federal Supreme Court jurisprudence here when there are fundamentally different relationships between the people and the government?
That's exactly right, Justice Montgomery. You should follow the state constitution's Article 2, Section 23, which protects jury rights to a greater extent than the federal constitution does. Now, under the 7th Amendment, you have a value in controversy limitation written into the 7th Amendment. You have a common law versus equity distinction written into the Seventh Amendment. We don't have that, textually speaking, in the state's constitution. So we are asking you to apply the state's jury clause. But if you do conclude that the state's jury clause does not provide protections, even to the extent that jarcossy provides under the Seventh Amendment, then you would have interpreted the state's constitution to give basically less protections for jury rights than the federal constitution.
Well, but we also have a different circumstance too, because jarcossy dealt with a legislatively created administrative or executive administrative agency. The ACC here is in our Constitution. Isn't that entitled to some recognition and a different way of approaching the enforcement authority?
Well, to the extent this court has recognized the unique character of the Corporation Commission, you have already done that in Johnson's Utilities and Sun City.
So what's in the Constitution? We've always recognized that the ACC is a constitutional entity. Doesn't that affect how we look at it?
No, because you have also held that the Corporation Commission is beholden to the entirety of the Constitution, including the Declaration of Rights. So you'll have to overrule Sun City, Johnson's Utilities if you want to go down that route. And again, Occam's razor, that would be a harder proposition to swallow. I want to quickly sort of touch upon this idea that, there's elements here and elements there, and they try to bring at least 4 different types of limitations or read those limitations into the jury clause. Again, Occam's razor, I keep going back to that. That's probably the theme of this argument, is what's the simpler explanation? When the framers said the right to a jury trial shall remain inviolate, we have a long line of cases in Arizona that has construed the meaning of those words, remain inviolate. And I said, we just look to pre-statehood practice. And pre-statehood, all of us agree that at a minimum, if there was a common law cause of action, there was a right to a jury trial. In fact, there is some evidence that the territorial legislature in 1901, for example, in Section 1389, which we have cited in our briefs, said there is a right to a jury trial either party can claim for both common law and equity. And then there is a 1914 case called Brown versus Greer, 16 Arizona 215, that construes remain inviolate to say, well, look at the 1901 statute. It says everything gets a jury trial. Now, that 1901 statute has subsequently been superseded by the 1928 legislation, and that statute has been repealed and it survives as Rule 38 of the Rules of Civil Procedure. What does Rule 38 say? You get advisory juries for equity cases as well. So that shows you the history and tradition in Arizona of robust protections for jury rights. But we don't, again, have to go there and sort of like give an advisory opinion as to what happens in equity cases, because we have a common law case here. Fraud, on a very basic level, securities are simply contractual promises given in exchange for a loan of money. If there are any misrepresentations that occur as part of consummating that transaction, fraud, deceit, cheating, all of these were recognized in William Blackstone's time.
Do we, I know nobody really addresses, I don't think, but is there any dispute that the framework provided by Darendal applies in a civil context as opposed to a criminal context?
Right, so this court has assumed that in the Soto versus Sacco case, 242 Arizona 474. That was a civil jury case. So, you just have to basically make that explicit what was assumed before.
Okay.
I see my time is running out, so I'll come back for rebuttal.
Thank you. Please.
Good morning, Madam Chief Justice. May it please the court. I'm here on behalf of the state. I'll be talking about Article 15, and Mr. Kitchen for the Corporation Commission will be addressing the Darendal issue. The last time I was in front of you was down at the U of A regarding the EPM. That case was about imposing requirements from one statutory regime onto a very different regime, contrary to both text and longstanding practice. The court rightly and quickly rejected that attempt. This case is very similar, but at the constitutional level. The text of Article 15, Section 19, as the Chief pointed out, expressly confers on the Corporation Commission itself, not a court or a jury, the authority to impose fines for violations of its rules or regulations. The first legislature enacted a parallel statute, ARS 424, which has remained in effect and unchanged since 1912. In 1959, the Attorney General issued an opinion that recognized the Commission's authority to issue fines for violations of its rules and regulations. Thus, the Commission has long been authorized to enforce the Securities Act and its implementing regulations through administrative action without a jury. And in 1972, the people amended the jury clause without countermanding this practice, and also at the same time rejected an attempt to abolish the Corporation Commission. But I want to dig deeper into Article 15, Section 19, because I think that's the determinative issue in this case. That section provides that the Corporation Commission shall have the power and authority to enforce its rules, regulations, and orders by the imposition of such fines as it may deem just within the limitations prescribed in Section 16 of this article. There are 4 ways in which this sentence makes clear that the corporation is authorized to impose fines. First, it emphasizes the Commission's power and authority, not just one, but both. Second, it states that the Commission has the power to enforce its rules, not to ask another body to enforce its rules. Third, it states that the Commission can enforce its rules by the imposition of fines, again, with the Commission as the actor. And fourth, it states that the fines are, quote, as it may deem just. And in this sentence, it is the Commission, so it's as the Commission may deem just. Each of those parts shows that Section 19 authorizes the Commission, not a court or a jury, to impose fines. Likewise, Section 6 of Article 15 contemplates proceedings before the Commission. And everyone in this case agrees that the Commission can't impanel a jury. That's part of the judicial power. Article 15, Section 4 gives the Commission specific parts of the judicial power, but not this one. So the Commission cannot impose the fines authorized by Section 19 through the imposition of a jury.
What happens after the imposition of fines? I take it that the Corporation Commission is subject to the Administrative Procedure Act. It would go up to, if they wanted to appeal, eventually it would go to the Superior Court. Is that appeal, I take it, have deferential review, or is there any kind of de novo review of the fine?
Excellent question, Your Honor. Yes, it's subject to the administrative review proceedings in ARS 12910 and those sections. Whether that is deferential or not is partly related to a pending case before this court regarding the meaning of 12910F and how to reconcile the different parts of that tricky subsection.
If it's de novo, could there still be room for a new jury trial on that?
I don't believe the de novo provisions under 12910C or D apply by their plain text to reviews of commission proceedings. So it's a question, it would be review under 12910F. There's substantial deference in there, but then there are the sentences after that say it's reviewed without deference to the findings of the agency, and so this court has to figure out what to do with those things. You know, I think that the 44, 2036, and 2037 structure is instructive here. As some of your honors pointed out, those provisions allow the commission to either choose to proceed administratively in 2036 or to proceed in Superior Court under 2037. There are some additional benefits from proceeding in Superior Court, which Mr. Kitchen could probably tell you about better than I can. But you can get a preliminary injunction in Superior Court on the right facts. My understanding is the commission can't do that. So there might be good reasons, not just forum shopping reasons for the commission to go to Superior Court in certain cases. But the legislature clearly contemplated, consistent with all the other authorities I've described, that the commission could proceed administratively. And the EFG is essentially asking you to overrule that and hold that that's unconstitutional.
So backing up a moment, it sounds like as to your threshold argument, you were embracing the Court of Appeals holding, which didn't have a heck of a lot of reasoning attached to it, but that the Corporation Commission provision of the Constitution is pretty much self-contained. That if you don't find something like a jury right in it, the power to implement its powers, is unaffected by the remainder of the Constitution. Is that correct?
I would describe our theory as a refined version of the Court of Appeals theory, which is not just that there's an absence of a jury in Article 15, but that there's express authority for the Commission itself to be the entity that imposes fines under Article 15.
Have to apply due process?
Yes, certainly.
Why?
Due process applies, the excessive fines clause applies, the equal privileges and immunities clause applies, because you try to read the Constitution as a whole, of course, and all of those limitations apply to all governmental entities. The jury clause is different because it's textually inconsistent with Article 15, Section 19, because there's no way to have a jury proceeding in the Corporation Commission, and Section 19 expressly tells us that the Commission can be the one to impose fines. So we're not trying to get due process out of it, nothing like that. It's just a question of whether you can have that jury proceeding in this more specific provision, and we think that the text of the Constitution is very clear there, Your Honor.
I want to ask you a question about the meaningful difference between 36 and 37, but I think you've told me I have to wait.
Well, if you ask, I'll do my best, and you may get a better answer from my friend. I'm happy to answer other questions on Article 15. If there aren't any, then I don't want to take more of the court's time. I do want to close with one quick note on the Darendal issue. EFG's arguments on Darendal could work a sea change in Arizona law, and there could be very wide-ranging implications from administrative law to victims' restitution, and the court may well have to grapple with those issues in one or more appropriate cases. But the court does not have to here, because Article 15, Section 19 expressly answers the question presented in this case. And because prudence is one of the greatest judicial virtues, I would urge the court to resolve the case on the Section 19 ground and leave the broader jury issues for another day. There are no other questions on Article 15. Sit down, give Mr. Kitchen the rest of the time.
Thank you, Mr. Bender. Okay, Mr. Kitchen. Probably behooves you to start with answering Justice Montgomery's question.
Certainly, Your Honor. Paul Kitchen for the Arizona Corporation Commission. And to answer your question, Your Honor, the differences between 2036 and 2037, as you noted, 2037 allows for the possibility that there could be a jury right implicated in Superior Court. 44-2037 doesn't grant a jury right in a commission proceeding in Superior Court. It just recognizes that if there is one, this section is not altering the status quo. Whatever jury rights you have remain, they're not being eliminated. But there's a significant contrast between 2036, where the legislature, you mentioned that the penalties are different in Superior Court. Between those two provisions, they're the same. It's $5,000 before the commission, or under 2037, it's $5,000 before the Superior Court. But the legislature, in writing these two things, is contemplating the possibility of a jury right in Superior Court, is not contemplating any possibility of a jury right before the commission. And that's because the legislature knows that it has written the Securities Act in conformity with the Constitution, in conformity with Article 2 and with Article 15. So they've recognized there's a possible difference of treatment between the two venues, and they've accounted for that in the Act.
But the legislature did not preclude transfer to Superior Court. I mean, why couldn't there be a change of venue in this case to account for what's in 2037?
Well, Your Honor, if the framers had contemplated that as a possibility, they would have explained that in Article 15. They would have mentioned that if you need to remove from the commission due to a jury right, here's the mechanism by which you do that. Or they would have allowed the commission to impanel a jury. They didn't do either of those things, which reflects the fact that in the framers' mind, there's never going to be a conflict. Article 15 can be reconciled with Article 2, Section 23, because the framers understand that they're not going to interact.
So it's inviolate except if it is impliedly removed by another section of the Constitution.
Well, Your Honor, it's not that it's being violated. It's that inviolate means unchanged. It doesn't mean that it's universal. It means that where it exists, it's not being removed. But what I'm saying is that the framers recognized that the common law torts protect the rights of private parties who've been damaged to seek compensation from the person who damaged them. And that's never what the commission is going to be doing. The commission is serving a public function, an enforcement function. And that's why the framers, haven't contemplated the possibility of a jury right being implicated in a commission case, because the commission just is not bringing common law causes of action for common law purposes.
Does it matter what the purpose is of doing it on behalf of the public? I mean, when you're prosecuting criminal charges, you're doing that on behalf of the public. You're really not doing it just for the victim of the crime. So what authority do you have that suggests that the fact that you're filing suit or filing administrative proceeding for the public, why that makes a difference?
Your Honor, the difference, I think, is in the common law itself, which is that the sort of ancient history is that criminal charges, entitle you to a jury, and that's the government bringing that. If the government were to bring a common law claim for a breach of contract or for some tort that it has suffered for some reason, if the government is trying to relieve its own damages that it's been suffered, then that could be a common law claim. But
do you have any authority? I mean, and that was part of the reason I was asking initially about, does everybody just agree that Derendal applies? And you're looking, some of the considerations you're talking about, criminal, would matter if there's a difference. But from what my understanding, everyone agrees. You look at common law antecedents, and so some of this issue of the public bringing it, because you're not entitled to a jury trial on all criminal procedures either. There are some, which is what this sprung from, which ones are and which ones aren't. So again, and with that in mind, does it matter that this is brought by the state on behalf of the public?
Well, Your Honor, I suppose the difference isn't that it's being brought by the state, but that the purpose is that it has regulatory purposes beyond what the common law accounted for. And there's a few examples of cases that touch on this. One is Williams versus King, which was looking at a statutory claim for alteration of a water course without authorization, and it applied Derendal, and it compared this to common law negligence, nuisance, and trespass. And it found those common law claims distinguishable because the statutory claim is part of a cog in a comprehensive regulatory scheme. So it found that when the legislature is trying to regulate broadly, it is not then a common law claim. Mack versus Dellas, criminal case, relied in part on the fact that the new statutory offense there had an element added so that the offense is highway obstruction. And in Mack versus Dellas, it noted that the legislature had added a new element, which is permitting. Like, you can obstruct the highway if you had a permit. That wasn't true at common law. There was no permit that allowed you to commit that offense. And it noted that that new element had a regulatory aspect that wasn't present in the common law offense, and that was part of what distinguished them. Also, State versus Willis, this compares common law trespass with statutory first-degree trespass. And what was dispositive there is that common law had an element of breach of the peace, and the statute didn't. Yes, Your Honor?
Well, in a pair of decisions, this court has held, and Sell and Gunnison, that our securities law was modeled on the federal security law, and that we will follow federal jurisprudence unless there's a provision that differs between the two laws. And in fact, as Justice Palander pointed out in Sell, that was the express intent of the legislature when it adopted the securities law in 1951. Now, Jarkissi takes a very different view from what I think you've just expressed, which is this is a common law action. The nature of the civil penalties, which Mr. Dunnar pointed out, although they are $5,000 apiece, they can aggregate into quite substantial sums, and that is a common law action. It is an enforcement action. It's got a punitive aspect to it. Why is Jarkissi simply irrelevant here? And if so, doesn't that require us to reconsider what we said in Sell and Gunnison?
Your Honor, jarcossy is distinguishable for a few reasons, and the first one is that Article 15 distinguishes the Commission from the SEC. It's also distinguishable because jarcossy is applying a different standard than Darendal. So the starting point of their analysis is different, so their focus is different. They're focused on remedies, where that is not what matters here.
But Darendal, asks, as the chief said, is there a common law antecedent? And jarcossy is very, very clear on that. The fact that enforcement has been assigned to an agency, and we have, it's a statute rather than a common law action per se. This is derivative of the common law antecedent.
So, Your Honor, the history is a bit more complicated than that. The federal securities laws are themselves modeled on the state securities laws. The states led the way here. The federal government had its federal act, and then a lot of the states have adopted some of the language as being useful. But as pointed out in our supplemental brief, there is a direct antecedent of the 1951 anti-fraud provision, and it's the 1921 Securities Dealers Act. It's a criminal offense. It's not the common law. Arizona was prohibiting fraud in securities transactions 12 years before the federal government passed its first Securities Act. Later, the legislature, determined that a criminal offense was not enough, so we're going to create this regulatory offense, and we're also going to add an express cause of action for private parties. But apart from that, also, Silla and Gunnison say that we're happy to depart from federal precedents when there's a good reason for doing so. And the clearest reason is that jarcossy is applying a different standard. So, of course, the outcome is likely to be different here. But apart from that, the legislature articulated purposes, express purposes of the Securities Act in the preamble to the 1951 statute. It's intending to protect the public. It's intending to promote fair business practices. It's intending to suppress fraud and deception in securities transactions. And the legislature found that it was appropriate to do that by allowing the commission to try to help in that prevention effort. The commission, in that sense, has a broader ambit. The legislature's intentions. Sorry, I thought that was a question at the beginning. The legislation intentions are broader. Also distinguishable is that in jarcossy, the emphasis was on the remedy, so comparing the elements was an afterthought. And the Supreme Court didn't appreciate, in part because the elements are different there, but statutory securities fraud in Arizona can be proven with none of the elements of common law fraud. And the petitioners said that substantial similarity is a very low bar, but the Court of Appeals has applied Darendal 10 times, and none of those examples gets anywhere close to finding a common law antecedent between claims that can be proven with no common elements. And that's why the petitioners don't point to any of those examples as being their best case under Darendal. There is no application of Darendal that can survive that. Darendal itself distinguished offenses based purely on a change of a mens rea element. Mack versus Dellis also emphasized an intent element. Nyquist distinguished two claims based on only a change in the injury element. And here the Securities Act doesn't have the intent element of a common law fraud.
What about Sulavka and Kalali? Sulavka, shoplifting by concealment was unknown at common law, but substantially similar to common law larceny. Kalali, new unitary crime of theft combining common law offenses of the same character. That seems to be, both of those seem to support the argument that the other side is making.
So, Your Honor, here, Kalali doesn't apply because there is no common law equivalent of 44-1991 A1 and A3. A1 is a scheme to defraud, which requires no statement at all. A3 is a device, practice, or course of business that operates as a fraud or deceit, even if there's no statement and no intent. Sulavka is distinguishable because a close reading of the shoplifting statute shows that shoplifting really is common law larceny. They've taken the same elements and expressed them a different way. It's larceny from a store of goods. But otherwise, comparing the elements, it requires taking, it requires intent, all of the different ways you can commit shoplifting, those 5 different ways that you can do it: by concealment, by removal, by altering price tags. Those are just specific ways you can achieve asportation, which is sort of an arcane term, and the legislature has instead explained to the public what asportation means in that statute.
Chief, can I ask one clarifying question?
Yes.
So you mentioned there were three things that distinguish jargacy. I captured two, Article 15, Darendal. What was the third?
Your Honor, I see that I'm out of time, but may I briefly
yes,
answer?
of course.
I asked permission for you.
She did.
Thank you. I thought so. I didn't want to assume. The distinguishing thing is that
So you can ask it, but you can't answer.
Asked, not answered. Yeah, no, just quick, in the list, there were.
sure.
So I got
The
the first
SEC penalty is tiered based on fraud. Fraud is higher. Under the Securities Act, fraud has the same penalty as the registration violation. They're treated the same. And the SEC penalty for fraud maxes out at 145 times greater. And to the extent that that fraud can amount to a large number, it's always going to be dwarfed by the restitution figure. For example, in the more evident case he's talking about, the restitution was in tens or hundreds of millions.
Okay, thank you.
Thank you.
Thank you. Okay, Mr. Diner.
Few quick points. Section 1991 says defraud and deceit, but the statute does not define those phrases. So you have to give meaning to those words somehow. The legislature can be presumed to be acting with the understanding that common law has already defined those terms. They say that the commission acts in the public interest, but in our system of separated powers, juries are the ultimate and primary custodians of the public interest. They say we are asking for a jury in commission proceedings. Couldn't be farther from the truth. We are asking for a change of venue to superior court where trial would be by jury. That's an important distinction that even the Court of Appeals missed to some extent. The commission is many things. Its ALJs can be many things. Courts, they are not. Article 6 of the Constitution defines courts to include this court, courts of appeals, superior courts, justice of the peace courts, and municipal courts. Article 6, Section 17 gives superior court judges the power to summon and impanel juries. There is nowhere in the Constitution any provision that gives the commission or its ALJs the power to impanel and summon juries. So if somebody asks for a jury trial, that case must be dismissed. The administrative case must be dismissed. It should be brought in superior court.
Counsel, let me ask you a quick question, because you referenced that we look at juries as the primary custodians here. But didn't the people of Arizona sort of take a different look at that when it came to dealing with securities issues and public corporations by creating the ACC? Hasn't that somehow been subsumed within that and making the ACC commissioners directly accountable to the people?
No, so I grant you the premise that the framers were interested in preventing elected officials conniving with corporations. So they distrusted both corporations and commission elected officials. So the sort of a counterpoint to that was the jury, civil juries, and there are, a revolution was fought for the jury trial. The American Constitution would not have been ratified if they would not have put jury trials, civil jury trials in the Seventh Amendment. Non-bifurcation.
Your concluding thought, because you're.
I'm sorry.
I know I let you go a little bit.
I appreciate it. Just one quick point. Non-bifurcation. If a part of a case has a common law antecedent, the whole case goes to the jury for fact finding. Thank you.
Thank you. Thank both counsel for their arguments today. Excuse me. Contagious, I think.
Oh, no.
Thank you for your argument today and your briefing. We'll take the matter under advisement and issue a decision in due course. We will stand in recess as to allow the next case to come forward. Do my colleagues, anybody need to go back to get a new material? No? Yes? Yeah, we are. And we'll remain on the bench then until everyone's settled. Thank you.